This is one of the most egregious cases I've ever had.
That's it.
When you shoot and murder your mother, the woman that brought you into this world, and your sister, you're going to spend the rest of your natural life in prison. Hopefully someday you'll think about that. Get them out of here. I'm done.
This is ridiculous for me, not for you. That's basic law. It's been basic law in this country.
Next time it happens, I'll be asking for a mistrial with prejudice.
Some indication as to what the conflict. No, you didn't. Bond revoked. We're done.
Mr. Judge,
Bond revoked. Bond
I'm unable to
revoked. People sit.
Whoever can sit here at a tragic moment like this and laugh and smile when somebody has lost a family member, that clown, and that's what I'm going to call him, a clown, was sitting there smiling and laughing.
This is Amanda Kosal, who's accused of causing a deadly crash in Detroit, Michigan. In June 2016, Amanda had a fatal head-on collision with 31-year-old Jerome Zerker and his fiancée Brittany Johnson while driving under the influence. Tragically, the crash took the life of the father of 5, while Brittany was severely injured. Amanda was arrested and charged. The 25-year-old later pleaded guilty to operating under the influence, causing death. During Amanda's sentencing, Jerome's sister, Doreen, read a powerful victim impact statement written by his children.
Amanda, look what you did to my life. You ruined everything I had, like my dad's life.
While Amanda seemed to be moved by Doreen's words, a couple in the court found it amusing and enraging Judge Kiana Lillard.
Yeah, it's time for him to go. And I don't know who he is, but whoever can sit here at a tragic moment like this and laugh and smile when somebody has lost a family member. I mean, the entire time that Mr. Zerker's sister was speaking, that clown, and that's what I'm going to call him, a clown, was sitting there smiling and laughing.
Judge Lillard threw the man out of the courtroom, but the woman was not so lucky.
That you can go to, because if you don't know how to act, you can go to jail. So leave. Anybody that can sit there and laugh and smirk when somebody, take her, she's going in the back. She's going in the back.
It was Amanda's mother, Donna Kosal, who was sent to 90 days in prison for direct criminal contempt.
Ma'am, you are being taken into custody for criminal contempt. Your disruptive and disrespectful behavior disrupted today's proceedings, and you, ma'am, are going to the Wayne County Jail for 93 days for direct criminal contempt. Anybody else want to go? Try it. Try it. Oh, my mouth? Well, thank you. Your mouth got you 93 days.
Judge Lillard then had some stern words for the Kosal family.
Anybody else want to go? You can go too. This is a court of law, and these are very serious matters. And I understand you all are upset because your loved one is going to prison. But guess what? She's going to prison for the choices that she made. These people are here grieving, saddened, because a senseless act took away their loved one, and you all are sitting around here like it's a joke. Not in courtroom 502, not today and not any other day.
After order was restored, Amanda was sentenced to 3 to 15 years in prison.
So it'll be the sentence of this court that you will serve 3 to 15 years in the Michigan Department of Corrections.
The following morning, Donna appeared before Judge Lillard. She seemed a changed woman after just one night in jail.
Apologizes to the court and asks that you discharge the contempt hearing, Judge.
All right. Ms. Kosal, is there something you'd like to say?
Yes, I deeply apologize for what I did. I was under a lot of stress. I'm going through some doctor's appointments today for my heart. It's just everything overwhelmed, and I deeply apologize for what I did in your court. I just needed to get out, and it's been very hard for me this year, and I know for the other family, and I'm so sorry for what I did, and I know it was wrong, and I apologize.
After the apology, Judge Lillard had a few words of wisdom for the defendant.
What you have to understand is, as hard as this is for you to see your baby go into prison, imagine what that family feels like when their child's dead.
I understand that. I feel for them too.
So I hope that you've learned a valuable lesson from this. And I hope that it will serve as a message to anyone doing business in the Frank Murphy Hall of Justice, or any court for that matter, that there's just a manner, things have to be conducted in decency and order.
I
You
apologize.
can't come to court acting a fool. I know people watch a lot of shows on TV where you see different things happening in make-believe courtrooms that give people a skewed sense of reality, but this is real life here, and we just can't have people behaving like that. It can't be tolerated. So I will modify your sentence for direct criminal contempt from 93 days to 1 day with credit for time served, and you should be released today.
God bless you. Thank you.
Thanks.
And I apologize very sorely and for the other family. Thank you.
You're welcome.
While Donna Cosal spent a night in jail for laughing at the victim's family, how does it compare to smashing a computer in court? Like in the case of Antonio Rosales, who's on trial for assault and attempted murder in Sanford, Florida. In 2003, Rosales, who was homeless at the time, reportedly kidnapped a 10-year-old girl, dragged her into the woods, then strangled and assaulted her. The 41-year-old later confessed to the police. During his trial, as the prosecution was delivering closing arguments, Rosales expressed his discontent through a translator.
He doesn't know that I did that.
Then, out of the blue, he erupted. Fit of rage, Rosales grabbed a computer keyboard and smashed a monitor off the table. He then knocked over a table as two officers tackled him to the ground and attempted to restrain him. As officers struggled to subdue the defendant, the judge called for additional help. Rosales was handcuffed and hauled out of court.
Recess for about 10 minutes.
The next day, Rosales was convicted and sentenced to 3 consecutive life terms. While Antonio Rosales' courtroom fight couldn't prevent a prison sentence, what happens when a judge rebukes the prosecutor?
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn citation.
Next, we head to the Seminole County Circuit Court in Sanford, Florida, where a trial has just reached its conclusion. 46-year-old Lisette Gonzalez was convicted of driving under the influence. However, her attorney argued that Gonzalez was never given a breathalyzer or a blood test, and the arresting officer, Michael Wagner, had wrongfully recorded that she had tested above the legal limit in his official report.
Your Honor, not enough evidence presented for the jury to find the verdict that they did. They didn't do all the field sobriety examinations that should have been done. I respectfully ask that this court grant the judgment notwithstanding the verdict.
All right. This isn't a purely circumstantial case. And so I'm going to deny the motion for JOA.
After Judge Fred Schott granted the motion to overturn the jury's verdict, he moved on to a separate case related to the same defendant.
Now, we have this other case for driving while license suspended.
Gonzalez also faced additional charges after Officer Wagner's mistake had left her without a valid driver's license.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
Testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing.
The outraged judge then turned his attention toward prosecutor Diana Myers.
Are you going to no-pross that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this
Why
point,
wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer? Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely not,
citation.
Your Honor, and that is not true.
After dismissing Gonzalez's upcoming case, Judge Schott dropped another bombshell.
This whole case was fishy, and I have no idea how to. You know what?
Their address on file.
You know what?
The state intends to amend
I'm granting.
and proceed on
I'm rescinding the sentence. I'm granting the JOA.
Judge Schott reversed his decision and acquitted the defendant on the spot.
So you're granting it because you don't agree with the state's decision on
I'm granting the JOA in fairness.
In fairness, because we don't like the state's decision today, Your Honor, on the case.
No, you don't. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion to JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to kill me? No.
Thank you, Your Honor.
It should have never been. Never.
Thank you for letting us know that, Your Honor.
In the end, Lisette Gonzalez's case was dropped, and she walked out of the courtroom free of all charges. While a prosecutor was reprimanded for providing false evidence, what happens when a defendant throws a table at the judge?
You have 42 days to appeal. You're remanded to the custody of the Department of Corrections for service of this sentence.
Like in the case of Jaleel Hoskins.
Did you kill Latrice Mays?
No, I did not.
In March 2013, police responded to a domestic violence call made by 26-year-old Latrice Mays against her boyfriend, Jaleel Hoskins.
Neither one of you had any injuries, so at this point, I know the two of you aren't getting along this morning, but I don't have enough to arrest either one of you. But I can tell you guys aren't getting along. Now, certainly I can't make you leave, can't make him leave.
The officers offered to take Mays someplace safe, but she refused.
If you have somewhere you can go, maybe I can give you a ride there. If you don't have anywhere to go, I can take you to a shelter. And if you don't want to do either of those, you don't have to. In fact, you can stay here.
Hours later, Hoskins strangled Mays to death and dumped her body at an apartment complex. Her body was never recovered, as police believed it to be incinerated. Hoskins was arrested and charged with open murder, but he maintained his innocence.
Did you kill Latrice Mays?
No, I did not.
The first few days of the trial are startling, as witness after witness testify against Hoskins.
I guess he choked her or something.
Did he say he choked her?
Yes.
If he said, I did her, I need some help, I can't carry her by myself.
Much to the relief of the victim's family members.
Hoskins pleaded guilty to second-degree murder.
It's just a relief to know that, it's all said and done, and that he finally admitted to his guilt of choking her and putting her body in a dumpster and disposal.
During sentencing, Mays' mother and aunt had a chance to confront her killer.
You tell me how I explain what happened to their mom.
First of all, I want you to stand there and look at me and quit standing there looking at the ceiling like a little coward. I want to face you and I'm going to tell you exactly how I feel.
While Hoskins seemed remorseful during the victim impact statements, what followed was utter pandemonium.
You have 42 days to appeal. You're remanded to the custody of the Department of Corrections for service of this sentence. Thank you.
Your Honor.
As Judge James Redford slapped the defendant with a hefty prison sentence, Hoskins knocked down a lectern and charged toward the judge.
Your Honor.
He was immediately grabbed by 3 deputies and removed from the courtroom. As Hoskins was being ushered away, a brawl broke out between the families of the victim and the defendant.
Court's in recess for 15 minutes.
Ultimately, Hoskins was sentenced to 50 to 100 years in prison for murdering his girlfriend. Hoskins' disregard for the court system is appalling, but as we see in the next case, it's not always the defendants who stun the courtroom with their shocking antics.
You're saying you can't be fair and impartial to both sides. You're going to completely throw out our entire justice system. You're off this jury. You're removed. Go home.
Take, for example, Judge Richard Scotty, a courtroom veteran who has 2 terms as a governor of Nevada State Bar under his belt. Today, he's presiding over jury selection in the trial of Jose Azucena, Azucena is facing 40 counts of sexual misconduct, including first-degree kidnapping and sexual assault of a minor under 14. Police say that he used candy to lure multiple youths to the Northeast Valley apartment he shared with his wife before attacking them.
Many of the details are too graphic for us to tell you about, and others are simply disturbing. In one case, the report indicates a victim says he took her into his apartment where he tied her up and taped her mouth shut before assaulting her. Police say he also told victims he would harm or kill their parents if they told anyone.
Yesterday was a contentious day of jury selection in the court, and as day 2 kicks off, Judge Scotty is in no mood for trivialities.
Okay, so can you be fair to both sides?
I think I would be biased.
Azucena's attorney questions potential jurors, and as one juror in particular admits that she doesn't think she can remain impartial, it hits a sharp nerve with the judge.
You didn't say that yesterday.
Well, I said I had
No, listen, what we're not going to have in this jury is people coming in overnight and thinking up and trying to make it up now so they can get out of the jury. That's not going to happen, all right?
An argument ensues between Judge Scotty and the woman, who is just out of camera shot to the right of the screen. Clearly incensed, the judge launches into a foul-mouthed tirade.
Right, because if I find that someone said something yesterday under oath and changes it because they're trying to fabricate something to get out of serving on this jury, there's going to be repercussions, right?
I
now,
did
what's
say,
going on here?
I
Tell me
did
what's
say.
going on.
I said I had other issues yesterday, and you said you'd get back to me.
He continues with his incredible rant, and as the juror scrambles to explain herself, you won't believe how Judge Scotty responds.
So why you got issues? Why can't you're saying that you can't be fair and impartial to both sides? You're going to completely throw out our entire justice system because you don't want to be fair and impartial.
In a shocking loss of control, the judge grows more and more irate, to the point where he picks up a pocket constitution and hurls it at the wall. Yes, you heard that right. He picks up a miniature version of the U.S. Constitution and throws it at the wall in anger.
So why you got issues? Why can't you're saying that you can't be fair and impartial to both sides? You're going to completely throw out our entire justice system because you don't want to be fair and impartial.
Your Honor, may we approach? Your Honor.
We can't approach. You're not going to be fair and impartial.
Like I said, with my nursing history, and I've been involved with child abuse, and I've been involved with incest with young girls that delivered 13 years old. It makes me rather, biased.
The juror gives a valid and understandable reason, but Judge Scotty just can't let it go, and he releases her from service in a very abrupt manner.
You're off this jury, and you're removed. Go home, right?
Azucena is ultimately convicted of 25 felonies and 5 gross misdemeanors, for which Judge Scotty sentences him to life in prison. However, his earlier outburst comes back to bite him when in 2020, Judge Scotty is brought up on ethics charges in relation to the incident. As a result of this, Azucena's conviction is overturned and a new trial is ordered, which is yet to come before the courts. Let's hope the judge throws the book in the right sense this time around.
Given the nature of his job, Judge Scott's outburst at a juror was shocking, but it's nothing compared to the pure rage this judge had when she realized a lawyer was using an AI version of himself in court.
May it please the court. I come here today a humble pro se before a panel of 5 distinguished justices.
Is this, hold on.
Like in the case of Jerome DeWalt, who's representing himself in an employment dispute in New York. In his first act as plaintiff, DeWalt submitted a video file for the panel of judges to review.
Okay, we will hear that video now.
There's just one problem.
May it please the court. I come here today a humble pro se before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
First, the judges thought the man in the video was DeWalt's lawyer. Truth was much worse.
I generated that.
I'm sorry?
I generated that. That is not a real person.
DeWalt, who works as an AI developer, used his skills to create a fake persona that could present his arguments to the court.
Okay, it would have been nice to know that when you made your application. You did not tell me that, sir. I received the application.
DeWalt got approval for a supporting video, but didn't explain the full intent.
In a news interview later, DeWald explains the reasoning behind his decision.
There's a couple of reasons. I had throat cancer 25 years ago, and so my throat tends to give out over a period of time. If a conversation is one thing, but talking for a long time, I start hacking and coughing, and it's difficult.
But there was another reason, too.
And then there's the pressure and the intimidation that a pro se feels in the courtroom by himself.
He was afraid he'd be intimidated by the panel and stumble over his words. So instead, he chose to clone himself.
I had intended to use a replica of myself, an avatar of myself. But I had some technical difficulties getting it completed. It was the first time I ever tried it. I couldn't get it completed by the time of the hearing, so I had to go with James, who you see there is much more handsome than I am.
Back in court, however, the judge didn't seem too pleased.
I don't appreciate being misled. So either you are suffering from an ailment that prevents you from being able to articulate, or you don't.
Unaware of his medical history, the judge suspected another ulterior motive for the video.
You are not going to use this courtroom as a launch for your business, sir.
The judge may seem harsh now, but she's just getting started.
Shut that off. If you want to have oral argument time, you may stand up and give it to me.
I apologize.
You have 5 minutes.
DeWald was forced to give his argument himself. Later, he says the judge seemed to regret the outburst.
Later, when I was giving the argument, she acted as though she was maybe felt she had been a little bit harsh with me. So she was being she was being encouraging to me, shall we say. And I did send in a letter of apology. So far, everything seems to be all right.
DeWald's case has yet to be concluded, but it looks like his sentence won't be affected by the misunderstanding. DeWald's misstep may have been unintentional, but how does that compare to a prosecutor who does their job so badly that the judge has to step in?
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
Like in the case of Kyle Rittenhouse, who's charged with 5 counts of homicide in Kenosha, Wisconsin. In 2020, 17-year-old Kyle Rittenhouse joined a racial justice protest in Kenosha, Wisconsin, armed with an assault rifle. Rittenhouse claimed he intended to be a medic and brought the rifle for self-defense only. However, he quickly realized he was out of his depth and ran toward police to escape the fight. Then, he claims protesters followed him, threatening to get him. That's when he fired the gun. Now in court, Rittenhouse is facing charges for killing 2 protesters and wounding 1 more. His attorney painted a perfect picture of self-defense.
It wasn't until you pointed your gun at him that he fired, right?
Correct.
However, the prosecution had a bit more trouble.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me.
The prosecuting attorney tried to use Rittenhouse's silence against him, a direct violation of his Fifth Amendment right.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that.
But instead of admitting his mistake, he insisted the judge was the one in the wrong.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
Well, I said you were over the line. close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Even the defense attorney was fed up.
He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Rob.
But eventually, the jury came back with their verdict.
The defendant will rise and face the jury and hearken to its verdicts.
We, the jury, find the defendant, Kyle H. Rittenhouse, not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read?
No.
Would you wish the jury polled?
Rittenhouse almost fainted with relief when he heard his sentence. But how does that compare to a defendant whose sentence fills him with murderous rage?
The bruises, some of the bruises were in the shape of a belt buckle.
I ain't gonna let you sit here and say no crazy shit about me, man.
Like in the case of Elise Ortiz Nieves, who's facing charges for felony murder and first-degree child abuse in Grand Rapids, Michigan. On June 13th, 2017, Ortiz was babysitting his girlfriend's 7 children when he realized one of them, 4-year-old Giovanni, wasn't breathing.
Kent County Sheriff's Department says that he was watching 7 kids this morning who live here at this house on Green Meadow Street Southeast. Deputies received a call about a 4-year-old who was not breathing.
He was rushed to the hospital where he later died from blunt force trauma. At the hospital, doctors found evidence of child abuse, 2 broken ribs, cigarette burns, and bruises in various stages of healing. In court, Ortiz came face to face with the cold, hard truth.
You beat this child, you brutalized this child, and you tortured this child.
However, Ortiz maintained his innocence.
I'm going to continue to say I will take a lie detector test to prove that I never abused any of Sonia's kids or never Giovanni and never intentionally meant to hurt Giovanni but to help him.
The judge didn't believe him.
There is no question whatsoever that you committed this murder and that you beat this little boy to death.
I ain't gonna let you sit here and say no crazy shit about me, man. No, man, because he's saying he don't even know, man.
Sir, the testimony showed that you put this child and other child in a shower with ice cold water.
The judge tried to maintain order, but Ortiz was out for blood. It took 3 deputies, but Ortiz was eventually overpowered. After that, the judge called him back to hear his sentence.
You are the lowest form of human life that I've been able to observe or see. You are a monster, and quite frankly, you are evil. What you did was sickening and disgusting. We're done. Take him to prison, please.
Ortiz was sentenced to life without parole. Ortiz Nieves was outraged and looked like he was ready to fight the judge. But how does that compare to a lawyer who actually did fight the judge?
If you want to fight, let's go out back and I'll just beat you around.
Next, we go to the More Justice Center in Brevard County, Florida, where public defender Andrew Weinstock and his client are appearing before Judge John Murphy.
You're Mr. Runkles?
Yes, sir.
2 charges, assault and resisting. You have the public defender. Public defender, what do you want to do?
Did they file?
They have.
I'm not waiving.
Since the court already had a packed schedule, Judge Murphy wanted the defendant to waive his right to a fast trial.
All right. What do you want to do?
What do you want to do? I'm not waiving. If you want to set it for trial, set it for trial.
All right.
If you want to set it for docket sounding, set it for docket sounding. I'm not waiving in any.
Tensions in the courtroom reached an all-time high when public defender Weinstock refused to budge.
This is an emergency
if I
created by
had a
the
rock,
state.
I would throw it at you right now.
Stop
pissing me off. Just sit down. I'll take care of it. I don't need your help.
No,
sit
you know
down.
what? I'm the public defender. I have a right to be here, and I have a right to stand
I
and
said
represent
sit
my
down.
clients.
See, moments earlier, Weinstock had a confrontation with Judge Murphy while representing another client.
This is Mr. Rodriguez, public defender. What do you want to do?
Talk to Senator.
Tomorrow?
Your discretion.
Well, it's going to expire before I can get them in, so.
It's not my emergency.
Question. You want to set it for trial?
You can set it for trial if you want to set it for trial instead. Sure.
Well,
I'm not waiving. That's if the question is, am I waiving? The answer is, I'm not waiving.
Just say it.
Okay, I'm not waiving.
I don't care.
Well, I don't care either.
I just needed to set it for a date.
Well, normally we go docket zoning after that. If you want to go to the trial, we'll set it for trial. That's fine.
All right. Speedy trial.
However, what Judge Murphy suggested next was never heard of in a courtroom before.
If you want to fight, let's go out back and I'll just beat your ass.
Incredibly, both Weinstock and Judge Murphy went to the back of the courtroom and actually had a physical altercation. Courtroom microphones pick up what happens next.
He backed me up. He had me pinned to the wall with his right arm. And he brought his left hand back in a fist. Then he punched me in the face, hitting me here.
After a while, Judge Murphy returned to the courtroom alone.
Thank you.
I lost it.
Thank you, man. I'm sure.
I'm a Patriots fan.
Man, I'm an old man.
Later, the incident was investigated by Florida's Judicial Qualifications Commission, and Judge Murphy was charged with misconduct. The case eventually reached the Supreme Court, which ordered Judge Murphy to be immediately suspended and permanently removed from his post. Weinstock later resigned from his position at the public defender's office. While Judge John Murphy ruined his career by fighting a lawyer, how does it compare to threatening to kill a judge? Like in the case of 27-year-old Tobias Roman, who was facing multiple felony charges in Bakersfield, California.
Threatening with the intent to terrorize, exhibiting a deadly weapon other than a firearm, and stalking.
3 days earlier, Roman was arrested after he allegedly tried to rob a mall employee and threatened to kill her with a knife. Today, Roman was facing Judge Charles R. Bremer, and right off the bat, things went off to a rough start.
Roman, stand up.
I'll tell her, I can't stand up right now. If I'm right here,
stand up, Roman.
What?
This is BF 140.
After the defendant was on his feet, Judge Bremer started proceedings.
Mr. Roman, what is your true and correct name?
Tobias, my first name. That's it. Giggles or Tobias. That's it. Don't call me nothing else.
At this time, I will appoint the public defender to represent Mr. Roman. The charges, Mr. Roman, are attempted robbery. Hey, Mr. Roman, you need to be quiet.
Yeah, you need to be quiet.
Judge Bremer gave Roman a final warning. The defiant defendant refused to budge.
You have one more chance, and then you're going to be removed from the courtroom. That'll be your choice.
Don't talk. Go ahead.
All right. You need to leave.
As he was being removed from the courtroom, Roman had one final comment for the judge.
I'd like to note for the record, Mr. Roman's statement on the record that he will murder me if he sees me, and I'm going to request law enforcement take the appropriate action.
Tobias Roman was later charged with threatening a public official and sentenced to 8 months in prison, while a defendant threatened to murder the judge. In this next case, one lawyer's childish behavior leaves the judge speechless.
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking.
This is Melissa McNeil, who's defending Nicholas Cruz in the infamous Parkland school shooting case. In 2018, 19-year-old Nicholas Cruz had a deadly plan.
You're all going to die.
Cruz entered Stoneman Douglas High School with a gun hidden in his guitar case.
Cruz opened fire in the first floor hallway of Building 12.
Oh my God!
Photos and videos from the shooting flooded social media.
Holy. Oh my God!
While surveillance video showed what was happening outside. But by then, 14 students were already dead, and others were seriously injured.
I have the gunshot victim. I have the gunshot victim.
Just hours after the carnage, Cruz was arrested and charged with 17 counts of premeditated first-degree murder. At court, Cruz acted more or less composed. It was his defense team that was the problem. During active trial, the defense team talked, shouted, laughed, and even flipped the middle finger at the judge and at the victims' families. The judge wouldn't stand for it.
It's got to stop. This is a courtroom. It needs to run like a courtroom. It's become somewhat of a playground, okay? I don't want anyone talking back and forth to one another. It's inappropriate. You all know better than that. Don't do it.
She reprimanded them in front of the entire courtroom.
I don't want any further rude or disrespectful behavior. It's gotten quite out of control.
But if you thought the defense team would rethink their behavior, think again. One morning, the court geared up for the first of many witnesses brought forth by the defense. But the second court was in session. Defense lawyer Melissa McNeil dropped a bomb.
Yes, at this time the defense rests, other than putting in our records.
During each trial motion, both the defense and the prosecution have the floor to speak. When they're finished speaking, they rest, meaning, in this case, that the defense has no witnesses to bring.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and bring your records.
The judge is irate, and for good reason. The entire day was supposed to be dedicated to hearing the defense's witness. Apparently, they had none.
I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced a level of unprofessionalism in my career. It's unbelievable.
McNeil got upset at the judge's words, and she wasn't afraid to show it.
I have been practicing in this county for 20 years.
You know what? I don't want to hear it. I don't want to hear it.
Well, Judge, you're insulting me on the record in front of my client, and I believe that I should be able to.
Okay, you can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue.
Despite the tensions between the judge and the defense team, Cruz's case went forward as scheduled. This is the moment Cruz learned his sentence.
The court imposes a sentence of life in prison without the possibility of parole.
Cruz got life in prison for all 17 murder charges. After the trial, McNeil and the judge parted ways without further incident. Luckily for McNeil, this judge didn't hold her in contempt for her audacity. How does it compare to throwing a defendant out of court?
Hopefully someday you'll think about that. Get him out of here. I'm done.
Like in the case of Stefan Roby, who was facing charges of double murder in Saginaw, Michigan.
This is one of the most egregious cases I've ever had. When you shoot and murder your mother, the woman that brought you into this world, and your sister.
A year earlier, Roby allegedly murdered his mother, Leigh King, and 11-year-old sister, Charlia, inside their Saginaw home. Police said King suffered 2 fatal gunshot wounds to the back of her head, while her daughter was shot 2 times in the face, before Roby dragged her body inside and shot her for a 3rd time. The 22-year-old was arrested and charged with 6 felony charges, including 2 counts of first-degree premeditated murder. Roby pled not guilty and represented himself at trial. He was also made to wear a stun vest.
after police found multiple shanks in his jail cell. During the trial, a friend of Charlia testified that Roby had threatened to kill the victims just days before the shootings. After Roby rested his case, the jurors took 30 minutes to reach a verdict.
Guilty of first-degree premeditated murder of Charlia Vanessa King. Guilty of first-degree premeditated murder of Lee Andrea King.
At sentencing, Roby's grandmother took the stand and addressed her killer grandson.
My grandson, Stefan Roby, has been found guilty of being responsible for the deaths of two of the most vulnerable, non-threatening people in his life, his mother and his little sister. But in spite of this terrible crime, his mother would still want him to receive the mental health treatment that he so adamantly rejected in the past.
When Roby got a chance to apologize, he chose to complain and throw accusations at Judge Fred Borchard.
And I feel as though that most of my emotions didn't get past because you were distracted.
Well, that is totally untrue.
Well, when she was on the stand, your phone kept going off a couple times and you kept asking her, was it her phone? When I came into the courtroom, I seen you on the phone.
Not while the court was in session.
Okay, but your phone's still going off and you were still distracted by the phone.
No, that is untrue. That's totally untrue. And that has nothing to do with the sentence.
Yes, it does have something to do with it.
Do you have anything you want to tell me in regards to this sentence?
Yes, I want to vote for mistrial because I don't...
Deny.
After denying his mistrial plea, Judge Borchard threw the defendant out of the courtroom.
This is one of the most egregious cases I've ever had. When you shoot and murder your mother, the woman that brought you into this world, and your sister. And you're going to spend the rest of your natural life in prison. Hopefully someday you'll think about that. Get him out of here. I'm done.
Ultimately, Stefan Roby was sentenced to life in prison with no chance of parole for murdering his mother and sister. Stephen Roby wanted a mistrial because he felt Judge Borchard wasn't paying attention during trial and sentenced him unfairly. But sometimes the killer isn't mad he got sentenced. He's mad it wasn't the death penalty.
You need to be careful. Do you understand?
Well, he did that. That's what's happening anyway. It's framed.
All right.
That's the way it is. And justice will be served.
Like in the case of Jonathan Sander, who's facing 3 counts of homicide in Raleigh, North Carolina. Sander was arrested when a neighborly dispute led him to kill his neighbor's wife, and her mother.
Well, he is accused of killing 3 people in cold blood, and the murder trial of John Sander continues to be full of twists and turns.
Yes, it does. We now know that Sander told investigators that he went blank and doesn't even remember killing 3 of his neighbors in their home.
During the interrogation, Sander's voice was chillingly calm.
I just went blank, and the last thing I remember was seeing Sandy laying on the floor.
In court, Sander showed even less remorse.
There was no blood under it.
Mr. Sander, please be quiet.
It's fact.
Mr. Sander, Mr. Sander.
What were her last words?
What everybody else did that's watching us. No blood under that wound.
Sander was so disruptive that even the judge was sick of him.
Mr. Sander, please be...
This is my life involved. I was frank.
Remove him from the courtroom, please.
Remove me from the courtroom.
Hey, stop it!
Hey! Yeah!
His actions were even more heartless, considering the only surviving family member was in the audience watching him.
My wife, once she got shot, she said 3 words. 3 words. Oh my God! And she vanished.
Salvatore Mazzea could barely give his testimony.
I saw him with a gun point at my wife, and I tried to go back in the dining room to get something heavy to hit him over the head, but I didn't have a chance.
And Sander's repeated outbursts made things even more difficult.
Laundry room?
Yes.
And
you're telling me I blasted
Mr. Sander, get him out of here. Get him out of here. Get him out of here. Mr. Sander, Mr. Sander, Mr. Sander.
Sanders claimed he only shot 1 bullet, He blamed the 3 deaths on Salvatore Mazzea himself.
When I did shoot Sandy, I shot him low on his stomach one time. That's the one with the bullets that made the black marks. I barely wounded him, and I left. After I left, Sal Mazzella shot and killed his family. Why? For insurance money.
There was only one time Sanders showed emotion in court, and it was this.
Hey, Dad, I really, really love you. I also miss you. I miss you every day. I remember when we used to buy Hot Wheels and watch SpongeBob. If you were never to come back, I will be so sad. I will cry every day.
Sanders' wife came to court and read him letters from their 3 young children.
The family and cats miss you. I hope you get out of jail soon. Love, your best friend. I'm sorry.
But shockingly, Sanders wanted to set his own sentence.
You need to be careful. Do you understand?
Put me to death. That's what's happening anyway. It's framed.
All right.
That's the way it is. And justice will be served.
He asked the judge for the death penalty. Then, the moment he was waiting for.
We, the jury, by unanimous verdict, find the defendant, John Frederick Sander, to be guilty of first-degree murder of Sandy Mazzella.
The judge did not grant Sanders' request. Instead, he sentenced him to life in prison.
And when you take your last breath, you're going to die alone, and you're going to die forgotten.
Sanders' theory that Mazzea killed his own family was too ridiculous to entertain. But what happens when the defendant calls their judge every ugly name under the sun?
Who is this bitch, Cynthia Cuba? Tell me!
I think you allegedly tried to hit with the pliers.
Like in the case of Sherry Lynn, who's facing charges for felony battery and violently resisting arrest in Miami, Florida. Lynn was arrested after beating and or stabbing a woman named Cynthia Cuba with a pair of pliers. In court, things start off with a bang.
But have you ever been treated for any mental health issues?
Why don't you go fuck yourself first?
Another judge might have found that offensive, but Judge Grazier let out a chuckle.
I'm sorry, ma'am?
I said go fuck yourself.
Okay, well, I'm a little busy right now.
But soon enough, she gets down to business.
I'm ordering that you stay away from Cynthia Cuba. Do not have any contact with her, and you must stay away from her home and place of business. As to the other case...
Who is this bitch, Cynthia Cuba? Tell me!
I think you allegedly tried to hit with the pliers.
Apparently, that doesn't ring a bell.
The other case, F15-1426, the bond on count is $5,000.
Despite the verbal onslaught, Judge Grazier ignores her, and Lynn's lawyer makes an executive decision.
$5,000 and count 3 is $1,000. Have a nice day, ma'am. We'll try and get you into the hospital.
The judge sent Lynn to a psychiatric hospital to undergo evaluation before trial. Lynn's verbal attacks might have been unexpected. In this next case, however, the judge might not be so forgiving when an attorney starts screaming profanity.
So if I am outside there where my First Amendment rights are in full effect, I will say what I choose to say when I choose to say it, and that is my right in this country.
In the case of Machansi Kramer, who's defending a child custody hearing in Las Vegas, Nevada. Kramer's representing Jonathan King, who's fighting his ex-wife Shelby Bachman for shared custody of their 2-year-old Joseph.
Because my client is a UPS driver, his schedule, though, is not a set schedule. It varies. So he has to keep her notified of when his schedule is changing so that she's aware of pickup. She has told him now if he's more than half an hour late than what's on the order, he forfeits his entire weekend and can't see the kid. And she refused to allow him to arrange for a third party to pick up.
The judge, Sanda Pomerenzi, asks attorney Don Procopius his side of the story.
Has Joseph gone weekends that he would have expected to see his father without seeing his father?
He has not missed one weekend. Not one.
His statement directly contradicts Kramer as she rushes in to defend herself.
The threat was made.
I didn't ask you if the threat was made. I asked if it happened. You led me to believe that it was happening.
Ignoring the discrepancy, Judge Pomerenzi focuses on finding a solution.
What I see here is parties not being creative. not coming up with creative solutions to a problem that neither of them has control over.
Kramer's emotional response will be her client's downfall.
My client has come up with all kinds of solutions, Your Honor, and it comes down to what mom wants is what mom is going to demand.
Okay, I don't buy that.
Well, Your Honor, that's how it is.
What I'm telling you is, have you discussed this issue with Mr. Prokopius?
Yes, I have in the hallway.
Okay. And has it been a matter of making demands or saying, what are we going to do?
No, it's a matter of calling my client a fucking bitch.
No, if I did not. And if I was going to call her names, I would do it to her face, and Your Honor knows I would. So, and I would admit it to you if I could call her that.
This case took an unexpected turn, but Kramer only digs herself deeper.
I do have experience with you using inappropriate language.
And you know that I would admit it if I had done it. And if I was going to do it, I would have done it to her face. If she happened to hear me cussing in the hallway, that's because I cuss all the time.
Okay, but you know what?
Fed up, the judge tries to give Kramer a word of advice.
You want to be a sailor? Fine. Go be a sailor in your private life. Go be a sailor not practicing law, but don't be a sailor in my court or in my cases. So what I'm suggesting to you is, if you used an epithet, maybe not to her face, but to her attorney, that is absolutely inappropriate and unprofessional.
I didn't.
And ma'am, I warn you, one of these days, the state bar is going to catch up to that. Because if you read the rules, there is an ethical rule about fairness to opposing counsel.
But instead of setting her straight, the judge's words set her off.
There are also rules about treating people equally without regard to race, ethnicity, or gender. And so the fact that I work in an office full of male attorneys that cuss all the time and they have never been rebuked by a single judicial officer or opposing counsel, I find it highly objectionable that anyone complains about my language, because I know all kinds of male attorneys who have no problem picking up the phone and screaming cuss words at me. So if I am outside there where my First Amendment rights are in full effect, I will say what I choose to say when I choose to say it, and that is my right in this country.
Are you done?
For now.
Okay.
At this point, the trial isn't about the custody hearing anymore. It's about Kramer's foul mouth.
I don't care if you're male or female, and you know better than that. This is my case. This is my case that I will control. And if, in fact, I learn that you have engaged in that behavior again toward Mr. Prokopius, in this case, I will issue an order to show cause, and we will consider contempt.
Kramer goes off again. The judge won't have it.
Waste the court's time on irrelevant information, and I'm not going to go ratting out someone.
You are giving me a headache because you're yelling, and I don't like having a headache.
Well, I'm being attacked, Your Honor.
No, you're not.
And we are wasting time on something that is not relevant to this case.
Sit down, counsel. I'm done hearing from you.
Tired of arguing, the judge ended the trial for that day to resume at a later date. Hopefully, Kramer's actions won't affect the judge's ruling. At least he wasn't facing prison time for his mistakes.
But who in the right mind would send these texts? She is to be held without bail, pending trial in this matter.
Like in the case of Alexis Plunkett, a lawyer who's facing crimes of her own after illegally communicating with prison inmates in Las Vegas, Nevada. On December 5th, 2018, Plunkett reposted a post from the police department with photos of 29 recently arrested members of the 18th Street Gang. Plunkett's post, she said, "I see a confirmed snitch among them, and we have one rat at a minimum here." On a separate account, Plunkett also posted the photo of the alleged informant, therefore exposing their identity publicly. On top of that, jailhouse footage shows Plunkett offering a mobile phone to an inmate, also her ex-boyfriend. These two incidents led to a search warrant on Plunkett's devices, and the police didn't like what they found. In a group chat with other attorneys, Plunkett revealed that after she gave her ex-boyfriend the phone, he physically attacked her. Then, she confessed to sending out multiple hit jobs on him, saying, quote, "This POS will never survive prison now." One attorney responded to her messages, recommending that she stop. But of course, she didn't. She doubled down, saying she was going to take care of business first. And, as a cherry on top, said she's not joking. Within days, Plunkett was arrested and charged with intimidating a witness to influence testimony and dissuading a witness from testifying. Plunkett's lawyer swears she didn't mean it.
That still shows somebody in a bad situation venting about it. It doesn't show a serious threat, that the police never took this seriously as a real threat.
The prosecuting attorney has a different opinion.
She has said in these texts what she wanted to do. She wanted to have Mr. Arabello killed or down severely. She mentioned who would do it, particularly gang members, lifers, shot callers, her clients. She mentioned how she was going to pay for it, providing them televisions, legal services, whatever, for life. She is a danger to the community. And we do have concerns about the way she has been behaving with certain inmates. Something needs to be done about this, Judge, and we would ask you to do it.
As for the judge, he doesn't care that Plunkett has a law degree.
In a gang case, and we had the same text, there wouldn't be any hesitation for that person to be in custody. But who in the right mind would send these texts? Because, like I said, I've been doing this since 1982, and I've never even heard of this, let alone seen this.
He refused to drop the charges against Plunkett. She would have to go to trial. But would she wait for her court date behind bars? This is the moment she finds out.
She is to be held without bail pending trial in this matter.
In the end, Plunkett was suspended from the practice of law for 5 years and 1 day as a punishment for her crimes. Plunkett lost her career over bad decisions. Nothing compares to a lawyer whose first mistake is opening her mouth.
I just have the worst cold, Your Honor. Objection, character evidence. Once again,
put a lien on for 250. I wanted to pay it then.
If you open your mouth again, I'm going to hold you in contempt.
Like in the case of Curtis Meeks, who's facing serious fraud, theft, and arson charges in Austin, Texas. Unfortunately for Meeks, he chose the worst lawyer possible to represent his case, Mia Alexia of Alexia Law Firm. First, she appeared late to the Zoom meeting because of technical issues. She finally did arrive. Her excuse didn't make any sense.
Turn on your camera and your mic. How's that? Great. Well, I can hear you now. That's wonderful. Okay. I'm so sorry. I just have the worst cold, Your Honor, and may it please the court. I respect you immensely. So sure.
Then the court got down to business. According to reports, Meeks contracted builders to build luxury apartments on land that he didn't technically own. Served a TRO, a temporary restraining order, ordering him to stay away from the property. He ignored it.
They violated the temporary restraining order. Mr. Meeks and his agent were enjoined from enforcing an illegal and fraudulent deed of trust.
Trouble begins the moment that the prosecuting attorney, Mr. Coomer, begins questioning the defendant.
So, overall, how many attorneys have you hired to represent you in various capacities in this case?
Objection, character evidence. Well, I would say relevance, but just answer the question. Overruled as to that.
Attorney Alexia couldn't choose the right objection, but after this next question, that's the least of her worries.
Okay, do you understand my clients want to be paid for their work in building these luxury condo units at the Denville property?
Once again,
put a lien on for 250. I wanted to pay it then.
Curtis,
I want to pay 250,000.
Excuse me, Miss Alexa, please. If you open your mouth again and words come out other than objection and then a rule, statute, rule of evidence, etc., doesn't come out after it, I'm going to hold you in contempt. I'm tired of this. You don't get to just stop and start instructing the witness.
You'd think the threat of contempt would be enough for Alexia to reconsider her behavior, but that's not the case.
He doesn't know. He's had Miss Alexa. All right. Miss Alexa, if you continue to interrupt these proceedings, I am going to hold you in contempt. This is the second time I've had to tell you this, and it's happened many more times than two. Okay?
This is the last warning the judge will give. But Alexia doesn't seem to care.
What part of Exhibit D3 do you want to see?
Mr. Coomer, have you ever been Curtis Meek's attorney?
I have never been Curtis Meek's attorney. I am doing examination right now.
Okay.
Okay. So that
Alexia, I'm sorry, but I am holding you in contempt for again interrupting the proceedings, and I warned you 3 or 4 times. I am holding you in contempt. You may proceed, Mr. Coomer.
And not 5 minutes later, after an uncomfortable 3 seconds of silence, Alexia speaks again.
All right. Can we move on, please?
Just interrupt. Miss Alexia, you are not the judge.
This time, the judge wants to send a message.
So I'm upping your contempt. I'm going to issue a show cause order. You'll have an opportunity to argue why you shouldn't be held in contempt twice so far. 2 times.
3 minutes later, Alexia has an important announcement.
Your Honor, at this point, I am going to have to withdraw on this case. So the case
denied.
Judge immediately denied her withdrawal. Alexia is shocked.
So I must I must proceed with a withdrawal. Okay. I do not feel that the judicial temperament has been fair toward my client.
Meanwhile, Curtis seems glad to be rid of his lawyer.
You can ask me some more questions. I'm here to answer.
But Alexia is upset at his supposed betrayal.
I can't wait till the judge. I have Curtis. I have accurately and fairly represented you. I have invoked you to
All right. Okay, I'm cutting you off.
Yeah,
Mr. Coomer, your next question, please.
Thank you.
Your Honor, what I demonstrate or consider with your behavior is inappropriate.
Okay, well, you can file something with judicial conduct or
I know,
whatever.
And
you are now being held in contempt for interrupting again for the 3rd time.
The judge says next is pure savage.
I think he would be better off without you, frankly. So, but I am not excusing you. So don't.
I never made an appearance.
Okay.
She just told the court the legal jargon equivalent of I was never here.
You did make an appearance. Okay. This is like, okay, Mr. Coomer, you may proceed.
Just like that, the judge completely ignored Alexia's desire to withdraw. But Alexia had to get her revenge.
Okay. Were you personally served with the temporary restraining order on January 3rd, 2023?
Unbelievable.
That was the last straw.
That will be a 4th contempt for another interruption.
Oh, I'm sorry, Your Honor. I thought that it was muted.
Okay, I'll take that one off then.
At this point, the judge's main goal is to get through the hearing, and if that means absolving one of Alexia's contempt charges, he's willing to do whatever it takes. Fortunately for the judge, that goal will never be reached.
Let the record reflect that Ms. Alexis has dropped off.
That's right. Alexia simply left the call.
It's confusing, but I just want to get through and do what we need to do.
You can't get through because you just.
But Mr. Meeks has a lawyer, although she, in my opinion, was not doing great.
No, she wasn't.
Still, he's entitled to a lawyer.
The judge has a choice to make. Get through the meeting or respect Meeks' right to an attorney. The choice is obvious.
We are going to be in recess. That is the order of the court for now.
Alexia's client is probably better off without her. What happens when a judge threatens to rip up a plea deal?
If you're convicted of felony murder, you'll go to prison for the rest of your life. That means you'll die there. That's what I'm tempted to do.
Like in the case of Donta Wright, who's facing murder and robbery charges in Ann Arbor, Michigan. Wright was 17 when he shot and killed 18-year-old high school football athlete Jordan Klee during an attempted robbery. Two other teenagers were involved in the murder. 19-year-old Jermarius Ellison and 18-year-old Delrano Gracie both received 15 to 40 years in prison. As for Wright, he pleaded guilty to armed robbery, conspiracy to commit armed robbery, felony firearm, and second-degree murder.
How do you want to plead to counts 2, 3, 6, and 7?
I'm pleading guilty.
Wright then went on to casually describe the chilling details of the murder.
Did you agree and conspire with two other individuals, Delrano Gracie and Jermarius Ellison, to commit an armed robbery?
Yeah.
And who are you going to rob?
Jordan Fleet.
Jordan Fleet. And as a result of that armed robbery, what did you do with that gun in Mr. Jordan Fleet?
Shot him.
Where did you shoot him?
On the top. My head.
And did you kill him with that shot?
Yes.
During sentencing, a family member spoke on behalf of the victim's mother, who was too overcome with emotion.
I've lost laughter and love. I no longer have the hope of having grandchildren. I've lost the enjoyment of holidays and birthdays and of everyday life. This year was supposed to be a year of celebration, of senior pictures with prom and graduation and parties. Instead, it was a nightmare that no parent should ever endure.
However, the defendant showed no remorse and smiled throughout the statement. Wright then addressed the court, where he continued with his indifferent demeanor.
I'll be home soon. R.I.P. Keon. I love my family.
That's all you got to say.
But Judge David Swartz was having none of it and threatened to reject the defendant's plea deal.
I have never in 23 years approximately ever not accepted a sentence agreement between the parties because it's bargained for, sentenced by the parties. But watching you sit there, smile and laugh and shake your head like this was no big deal, I'm very tempted to just say, I'm not going to accept this sentence agreement. We'll go to trial. And if you're convicted of felony murder, you'll go to prison for the rest of your life. That means you'll die there. Mr. Bella, do you want me to accept this sentence agreement?
Now it was up to the prosecution to decide whether to dismiss the agreement or to pursue a trial.
With the victim's mother, as well as his grandparents and some family members, they understand that obviously this is the defendant who brutally murdered their son by shooting him in the back of the head. He's shown absolutely no remorse. And throughout the victim impact statements today, he smiled and laughed throughout the entire proceeding. However, the plea family does want to move on with this. They want to get some closure from this case. They want to try and forgive this defendant and all of his actions for what he did. And they are asking, as well as the people, that you proceed with the sentencing. Okay.
Wright had another opportunity to speak. This time he addressed the court through his attorney.
Your Honor, my client asked me to apologize to the court. His smiling was in no way meant as disrespectful either to the family, to the victim, or to this court. My client is 17 years old. He has some emotional problems and frankly was scared. And some people display fear by smiling. He really meant no disrespect. He does take this very seriously.
Ultimately, Judge Swartz accepted Wright's plea and sentenced him to 25 to 52 years in prison for the murder of Jordan Clee. While Donta Wright's disrespectful behavior almost sent him to prison for life, what happens when a defendant drops multiple F-bombs in front of the judge?
That's 90 more.
Like in the case of Milton Watts, who threw a tantrum in Judge Green's court. Things were off to a rough start when Judge Chris Green asked Milton about his failure to appear in court.
You were supposed to be here last month. You did not appear. Why weren't you here?
I had work. My mom didn't show up. Somebody died in the family. There was no reason for me to be here.
Well, it's not an engraved invitation, son. It's a court order.
Judge Green initially showed some leniency. He asked Milton to hire a new lawyer since the previous one had withdrawn from the case. But the 21-year-old continued with his smug attitude.
Your attorney withdrew, so you'll have to hire an attorney?
I don't need an attorney.
You're a lawyer?
Nope.
You want to talk to me about a bond with me? What do you want to tell me?
About what?
Bond?
I'm really good, to be honest with you.
Finally, Judge Green had enough. He charged Milton for showing contempt in the courtroom.
That's going to cost you 30 days in the county jail for contempt. Cuff him if you got the cuffs. Hold on. It's $5,000 cash surety bond, temporary, subject to the temporary protection order.
As the judge read out the charges, Milton started throwing a tantrum.
He just swore at the judge.
Judge Green tried to give him some counsel.
Can I give you a piece of advice?
What?
You can either make life easy or you can make life hard.
But Milton had other ideas. He continued his rant as Judge Green kept on adding to the charges.
I already ruined my life.
That's 60. You want to go for 90? That's 94. That's 180. That's 360.
I'm working at McDonald's. Now I gotta come here and my life up. You.
Milton's family members tried to intervene, but there was no stopping him.
Melvin, stop!
How many days you want to give me now? Are you sir counting?
Melvin,
Yeah, I'm at about a year right now in contempt, so.
He's got mental problems. He's not on medication.
Ma'am, I don't care.
I don't give a
Melvin, stop!
Everybody. You.
Melvin!
The power.
Good.
The power.
Good.
Finally, backup arrived. Court deputies took Milton away as his family looked on with disappointment. While Judge Green initially went up to 365 days in the heat of the moment, once everything calmed down, Milton was sentenced to 90 days in prison. While Milton Watts will be spending less time in prison than he bargained for, what happens when an attorney's faux pas could cost his client their freedom?
Judge, I can ask the witness.
No, you can't. No, you can't. Not without a factual basis.
Like in the case of Edward Belinkis, who's defending Michael Barrasone against 2 attempted murder charges in Long Valley, New Jersey. Michael Barrasone was an Olympic horse trainer, and his would-be victim, Lauren Kanarek, was his student. But their relationship quickly went south. Kanarek posted Facebook posts calling Barrasone a racist and an anti-Semite, among other things. Barrasone denied the allegations, but Kanarek kept posting. Soon enough, both Barrasone and Kanarek made police calls claiming they feared for their lives. Tensions came to a head when Barrasone took a pistol and paid Kanarek an unexpected visit.
911 operator 382, what's the address?
I've been shot in the home. Michael Barrasone shot me. Please help, please help. I'm losing a lot of blood.
Where are you?
Please help.
In the 911 call, you can hear Kanarek's fiancée struggling to subdue the shooter. Barrasone shot Kanarek in the chest twice and also shot at her fiancé. Luckily, they both survived. But as for Barrasone, he was sent behind bars to await trial for attempted murder. In court, Barrasone's lawyer was convinced of his innocence.
I am the only thing standing between this man and a wrongful conviction.
But there was another person wholly convinced of his guilt, Lauren Kanarek.
Yeah, within the minute I started talking, he pulled out a gun and shot me once, twice, directly in the chest.
Soon it was time for Belinkis to cross-examine Kanarek, but he made a mistake.
I don't even know what the factual basis is for that.
Judge, I can ask the witness.
No, you can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking for.
I'm asking you a question whether or not.
There's no evidence that it happened before.
Tried to insinuate that Kanarek couldn't be sure of when the shooting took place, but the judge didn't appreciate the move.
Immediately after the shooting, and I believe I can question the timing of the shooting based on their inconsistent statement, their motivation to lie.
No, you're not going to, not to create some alternate universe scenario without something in the record. You need a factual basis. That is black letter law 101.
Still, Belinkis pushed, saying her testimony was too unstable to trust.
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't, Mr. Belinkis, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing.
The judge was done with Belinkus.
Judge, okay.
That's my ruling. End of it.
After that, Belinkus switched his strategy to a not guilty plea by reason of insanity, claiming that Canarek's constant harassment drove his client to the edge. This was the moment Barrisone learned his fate.
With regard to count 1, attempted murder of Lauren Canarak, what is your verdict?
Not guilty by reason of insanity.
Barrisone almost fell to his knees in relief.